I was standing at my kitchen window with a hot cup of coffee warming my hands when I first spotted it. A small black drone hovering about 20 feet above my driveway, its little red LED blinking in the gray winter sky like some kind of judgmental Christmas ornament. For a second I thought I was imagining things. I blinked, rubbed my eyes. Nope, still there, hovering, watching, filming my half-shoveled driveway like I was some kind of snow removal criminal. That was the moment I knew things in Pinecrest Meadows, HOA, had officially gone off the deep end. Let me back up a little bit so you understand how we got to the point where a drone was surveilling my snow-clearing progress on a Tuesday morning in January. This whole mess started with Debra Whitmore, the self-appointed queen of the Pinecrest Meadows Homeowners Association. If you've ever lived in a neighborhood with an HOA, you've met a Debra. She's the woman who knows every rule in the CC and RS better than her own phone number, who keeps a dedicated folder on her laptop titled Violations, and who treats the monthly HOA meeting like it's a Senate hearing where she's both the prosecutor and the judge. I'm Joe Fisher. I moved into Pinecrest Meadows about 4 years ago when I bought the house at the end of Birchwood Circle. Nice house, good bones, 2-car garage, a big driveway that curves slightly before reaching the street. I liked the neighborhood. Quiet, well-kept, good neighbors. I knew there was an HOA going in, but I figured it was the standard kind. You know, make sure nobody parks a rusted-out boat in their front yard or paints their house neon pink. Normal stuff. Fine. I can live with that. What I did not sign up for was Debra Whitmore and her increasingly creative interpretations of what the HOA had the authority to do. The winter started out rough that year. We got hit with a big snowstorm right after New Year's, and I mean a serious one. About 14 inches fell over 2 days, and then temperatures dropped hard. We're talking single digits overnight, barely cracking 20 degrees during the day. The roads in town were a mess, and our little neighborhood was no exception. Everyone was out there doing their best, shoveling walkways, salting driveways, trying to dig their cars out before work. It was one of those communal neighborhood moments where everyone kind of nods at each other from across the street, breath puffing in the cold, shovels working in rhythm. I actually liked those mornings in a weird way. There's something honest about everyone fighting the same battle at the same time. The Pinecrest Meadows HOA had a rule in the CC and RS, Section 7, Subsection 3, that required homeowners to clear their driveways and walkways within 24 hours of a snowfall ending. I knew about that rule. I followed it. I'd always followed it. My driveway was never some frozen hazard zone, but this particular storm was tricky because it didn't really end in a clean way. It snowed heavy, then slowed to flurries, then picked back up again overnight, and that second night we got another 4 inches on top of what was already there. So technically the storm was still in progress when Debra decided to start issuing violation notices. I got the first notice in my mailbox on a Wednesday morning, the day after the main storm. It said I was in violation of Section 7, Subsection 3, for failing to clear my driveway within the required time frame. It was signed by Debra Whitmore, HOA Enforcement Coordinator, not HOA President, not HOA Board Member, Enforcement Coordinator. A title she had apparently created for herself at the last board meeting, which I'll get to in a minute. I stood in my driveway reading that notice, still holding my shovel, my boots crunching on fresh snow, the cold air burning my nose, and I almost laughed. The storm was literally still dropping flurries. There were still 2 inches of fresh snow on the pavement I had cleared not 3 hours earlier. I was actively shoveling, like mid-shovel, and Debra had already issued a violation. I went back inside, took a photo of the notice and a photo of my driveway showing the fresh snow cover, and sent a reply email to the HOA board explaining that the storm was ongoing, that I was actively clearing snow as conditions allowed, and that the 24-hour window had not yet elapsed because the snowfall had not yet ended. I was polite, professional even. I thought that would be the end of it. It was not the end of it. 2 days later, on a Friday morning, the temperature had dropped to about 8 degrees overnight. My truck took a few extra seconds to start. The gas fireplace was running constantly to keep the house warm. I had a pot of oatmeal on the stove and was trying to decide if I really needed to go out that day or if I could work from home when I saw it again. The drone. It came from the direction of the neighborhood entrance, which is where Debra Whitmore lives, coincidentally. It buzzed up the street at about tree height, then slowed and descended as it reached my driveway. I watched through the kitchen window as it hovered there, scanning. I could see a small camera mounted to the underside of the thing, and the lens was clearly pointed at my property. I grabbed my phone and walked outside in my slippers, which in retrospect was not my smartest move given that the temperature was in the single digits, but I needed to document this. I got a clear video of the drone hovering over my driveway, then panning to look at my front walkway and then back toward my side gate. I stood there long enough that the thing started drifting slightly toward me before it pulled back and flew off toward the street. I went back inside with numb toes and a recording on my phone and a lot of questions. The first question was whether Debra actually owned that drone, or if the HOA had somehow purchased it. The second question was whether either of those scenarios was legal. And the third question, the one that really started burning in my gut as I poured more coffee and warmed my toes in front of the fireplace, was whether the HOA actually had any authority to fly a drone over my private property to monitor my compliance with a snow-clearing rule. I already suspected the answer was no, but I wanted to be sure. So I spent that Friday making phone calls and doing research, which is one of the advantages of working from home on a snow day. I called my neighbor Frank DeLuca first. Frank lives 2 houses down from me and has been in Pinecrest Meadows for about 8 years, longer than almost anyone. He knows the history of the HOA, who's been on the board, what fights have been had, and most importantly, he's a retired paralegal. When I told Frank about the drone, there was a pause on the other end of the phone, and then he said, "She did not." And I said, "Frank, I have it on video." And he said, "Joe, I'll be over in 10 minutes. Frank showed up in his big insulated jacket and work boots, carrying a thermos of his wife's homemade chili, which I appreciated more than I can say because I was still not feeling entirely warm. We sat at my kitchen table and I showed him the video. He watched it 3 times without saying anything, and then he pulled out his phone and started looking something up. The Federal Aviation Administration has rules about drone operation. Most people know that. But what a lot of people don't realize is that flying a drone over someone's private property in a way that could be considered surveillance can run into privacy laws depending on the state. Our state had passed a specific law a few years back about unmanned aircraft systems being used for surveillance purposes, and the relevant section said that no person could use a drone to conduct surveillance of another person on private property without their consent. It was originally aimed at stalkers and paparazzi-type situations, but the language of the statute was broad enough that it could reasonably apply to what Debra had just done. Frank also pointed out that even if the HOA had some argument that monitoring common areas or street-visible property was their business, my driveway leading to my garage, my side gate, my walkways, those were not common areas. Those were my private property. The HOA had no easement over my driveway. They had a covenant that required me to clear it, but having a covenant about something doesn't give you the right to surveil someone's home from the air to enforce it. I called my attorney, Lisa Tran, that afternoon. She handles mostly real estate and HOA matters, and I'd used her once before when I first moved in and wanted someone to review the CC and RS before I signed anything. Lisa picked up on the second ring and I walked her through everything. The violation notice, the timing during an active storm, the drone footage I'd captured, all of it. She was quiet for a moment and then she said, "Forward me that video and the original violation notice, and go look up your HOA's bylaws. Find the section that lists what the board is actually authorized to do." That night, I dug up my copy of the Pinecrest Meadows HOA governing documents. I had a PDF of everything on my laptop, which I'd saved back when I reviewed them before buying the house. I searched for the word drone first, which returned 0 results. I searched for aerial and got nothing relevant. I searched for enforcement and found the section that described what the board was authorized to do in terms of enforcing the CC and RS. The enforcement section was pretty standard. The board could issue written notices, assess fines after proper notice and a hearing, and take legal action in court if fines went unpaid. That was it. There was no provision authorizing the board or any of its officers or self-appointed coordinators to conduct aerial surveillance of homeowner properties. Nothing even close to that. Lisa called me back the next morning and confirmed what Frank and I had already suspected. She said the drone overflight, if done intentionally to monitor my private property, likely violated the state surveillance statute. She also said the HOA had no authority under its own governing documents to conduct aerial monitoring of any kind. She said I should send a formal cease and desist letter to the HOA board, specifically naming Debra Whitmore, and that I should file a complaint with the state's HOA oversight office. She also mentioned that if Debra continued, it would be worth talking to the police about the surveillance law. I spent Saturday drafting that letter with Lisa's guidance. Outside my window, the temperature was still bitter, hovering around 15 degrees, and another inch of snow had dusted everything overnight. My driveway was clean. I'd shoveled it Thursday, and the thin overnight layer was nothing I needed to rush out and clear immediately. But I salted it anyway just to keep things tidy because I'm actually a responsible adult. I sent the cease and desist by certified mail and by email to every board member I had an address for, which was 4 people including Debra. The letter was polite but firm. It outlined the state surveillance statute. It cited the specific sections of the HOA's governing documents that did not authorize aerial monitoring, and it stated clearly that if any drone was flown over my property again for purposes of monitoring or surveillance, I would pursue all available legal remedies, including a complaint to law enforcement. I also posted in the neighborhood's Facebook group. I didn't make it dramatic. I just wrote a matter-of-fact post explaining that I'd received a violation notice during an active snowstorm, that a drone had subsequently been flown over my property in what appeared to be a monitoring operation, that I'd consulted with an attorney, and that other homeowners might want to check whether their own properties had been surveilled similarly. I included a screenshot of the drone footage with the GPS timestamp visible so people could see the date and time. That post got 37 comments in the first 2 hours. Turns out I was not the only one who'd had the drone experience. My neighbor across the street, a woman named Patty Osai, said she'd seen the same drone hovering over her backyard the previous week when she'd left her recycling bins out an extra day. Another neighbor, Marcus Webb, said he'd seen it near his property when he had a contractor's van parked in his driveway for longer than the HOA's rules technically allowed. A third neighbor, a retired teacher named Glenn Hardwick who lived on the other side of the development, said he'd actually confronted Debra about the drone at the last HOA meeting, and Debra had told him it was a community resource for maintaining neighborhood standards. A community resource for maintaining neighborhood standards. By spying on people's driveways from the sky. Glenn also posted the minutes from that board meeting, which he apparently had saved as a PDF. Sure enough, there was an agenda item from 3 months ago where Debra had proposed purchasing a drone for community oversight and CC&R compliance monitoring. The vote had been 2 in favor, 2 opposed, and Debra had cast a tiebreaker vote as HOA president, which she technically had the authority to do under the bylaws. So the board had voted to buy the thing, but barely, and at least 2 board members clearly had reservations. I reached out to those 2 dissenting board members. One of them, a guy named Terry Bloom who I'd seen at a couple of block parties, responded quickly. He said he'd voted against the drone purchase specifically because he'd raised concerns about whether it was legal and Debra had steamrolled him. He said Debra had then used her enforcement coordinator title, which he also confirmed she'd created for herself without a proper board vote, to operate the drone personally. He was frustrated and said he'd be willing to sign an affidavit to that effect. The other dissenting board member, a woman named Carol Shin, called me directly. She was clearly annoyed, though she kept her voice calm and measured. She said she'd been trying to document Debra's overreach for months, but felt like she was being brushed aside at every meeting. When I told her about the cease and desist letter and the possible violation of the surveillance statute, she said, "Good. Someone needed to push back on this properly." So now I had a coalition. Frank's legal knowledge, Lisa's formal representation, Terry and Carol on the inside of the board, a whole neighborhood's worth of people who were upset, and a video of the drone with a timestamp. I felt a lot better about things than I had when I was standing outside in my slippers in 8-degree weather watching that thing hover over my driveway. The HOA board meeting was scheduled for the following Tuesday. I planned to be there. So did Frank. So did Patty, Marcus, Glenn, and about 11 other neighbors who had signed up to speak during the public comment period after I posted about it in the group. The weekend before the meeting, Debra made a mistake. A big one. Sunday morning, I was at my kitchen table with my laptop open, going through emails, when I got an alert from my doorbell camera. Someone was at my mailbox. I looked at the live feed and saw Debra Whitmore, in a big puffy coat and a knit hat, standing at the end of my driveway with her phone out, taking photos of my property. Just standing there at 9 in the morning photographing my house, my driveway, my garage. Without the drone this time, just her personally. I captured that footage immediately. I also walked to my front door and opened it and called out to her from the porch in a totally neutral, pleasant tone. "Morning, Debra. Can I help you with something?" She startled. She clearly had not expected me to be watching. She lowered her phone and said, a little stiffly, that she was conducting an inspection as part of her role as enforcement coordinator. I asked her politely if she had a copy of the governing document provision that authorized her to personally photograph residents' private property from the street. She blinked. I told her I'd reviewed the full governing documents and didn't recall seeing that provision, and that I'd be happy to discuss it at Tuesday's meeting. She said something about community standards, tucked her phone in her coat pocket, and walked back up the street. My doorbell camera had captured all of it, including a clear shot of her face and her holding her phone up toward my house. I sent that footage to Lisa that afternoon. Lisa said that while standing on a public sidewalk and taking photos of the exterior of a house was generally not illegal on its own, the footage was useful context for establishing a pattern of targeted monitoring directed specifically at my property. She said we'd use it in the meeting as part of the larger picture. Monday was cold again, back down to about 12 degrees. Half the neighborhood had the same problem I did, which was that you could shovel in the morning and by afternoon there'd be another light dusting, and then overnight everything would get a fresh icy coat. The roads through the development were a hazard because the HOA's contracted snow removal service had apparently not salted the main road through the neighborhood in 2 days. There were actual ruts of ice on Pinecrest Drive, the main road in. I saw 2 cars spin their tires trying to get up the slight grade near the entrance. A UPS driver had to walk a package to my door instead of driving up because his truck couldn't safely navigate the ice. And yet the HOA had been spending its energy flying a drone over my driveway. I brought that up at the meeting on Tuesday night. The meeting was in the community clubhouse, which was a medium-sized room with a long table for the board at the front and folding chairs for residents. It was standing room only. I had not seen that many people at an HOA meeting since the great fence color debate of 3 years ago, which I won't get into but involved Debra, predictably. Debra was seated at the center of the board table when I arrived, flanked by the other board members. She had a stack of folders in front of her. She looked confident. I noticed that Terry and Carol, the two dissenting board members, were sitting slightly apart from her at the table, and when Terry caught my eye, he gave me a small nod. I had my own folder. Printed copies of the cease and desist letter, the relevant sections of the governing documents, a printed copy of the state surveillance statute with the applicable section highlighted, copies of my video stills with timestamps, and statements from 6 other homeowners who'd agreed to let me include their names and their accounts of seeing or being monitored by the drone. There was also the matter of the HOA's own finances, which Frank had dug into over the weekend. The HOA dues are collected monthly from all homeowners in the development. There are 82 homes in Pinecrest Meadows, and those dues are supposed to cover things like maintaining the common areas, snow removal on the main roads and parking areas, landscaping, and so on. Frank, using publicly accessible HOA financial disclosures that Debra was required by our state's HOA transparency law to make available, had found that the drone purchase had been made from the HOA operating fund. Not a special reserve, not a discretionary line item, the general operating fund, and the drone had cost $1,100. $1,100 from the general fund, spent on a surveillance device, approved by a 2-2 vote with Debra casting the tiebreaker, without any homeowner input or public notice meeting, and without any legal review of whether the HOA even had the authority to conduct aerial surveillance. The meeting opened with Debra going through routine business, which included the usual items like committee reports and upcoming maintenance. She moved briskly, like she wanted to get through the procedural stuff before the residents got to speak. But when it was time for the public comment period, I was first up. I walked to the little podium they had set up near the front, put my folder down, and started talking. I was calm. I wasn't angry or loud. I walked through the timeline starting with the violation notice during an active snowstorm, moving on to the drone footage, explaining the state surveillance statute and the relevant provision, and then covering the governing documents section by section to demonstrate that nothing in the CC and RS gave the board the authority to conduct aerial monitoring. I handed copies of everything to the board members. I put an extra copy face-up in front of Debra specifically. Debra interrupted me twice. The first time she said the drone was a board-authorized community tool and that everything it did was within the HOA's authority. The second time she cut in to say that my driveway had been in violation and that the HOA had an obligation to enforce its rules. I let her finish both times and then calmly responded. On the first interruption, I pointed out that a 2-2 board vote with a presidential tiebreaker is a legitimate vote under the bylaws but does not supersede state law, and that the board's authority to purchase and operate equipment is limited by what is legally permissible, which aerial surveillance of private property without consent is not. On the second interruption, I held up the photo I'd taken of my driveway during the active storm, timestamped to show that fresh snow was still falling, and I pointed out that the CC and RS themselves define the 24-hour window as starting when the snowfall ends, not during it. The room was very quiet when I finished, and then Frank stood up. Frank is a big guy, calm and deliberate, and when he speaks, people tend to listen. He laid out the financial issue with the drone purchase in clear terms that everyone in the room could follow. He explained the HOA transparency law and what it requires, explained that the operating fund expenditure had not been properly noticed to homeowners, and then he named the specific section of state law that requires HOA boards to notify homeowners before any expenditure from the general fund over a certain dollar threshold. $1,100 exceeded that threshold. The purchase had not been properly noticed. That made the expenditure potentially unlawful, and it potentially exposed every board member who voted for it to personal liability. Terry and Carol, sitting at the board table, Both nodded visibly when Frank made that point. Terry actually said out loud, for the record, that he had voted against the drone purchase and that he had raised legal concerns at the time which had been dismissed. Carol echoed the same thing. Debra was starting to look less comfortable than she had when the meeting opened. Then Patty Ose went up to the podium and described the drone hovering over her backyard. Then Marcus Webb talked about the drone near his property. Then Glenn Hardwick talked about raising the issue at a previous meeting and being brushed off. By the time the sixth homeowner had spoken, the room had the energy of something that had been building for a long time and was finally being let out. Near the end of the public comment period, someone new stood up. A woman I didn't recognize at first, sitting in the back row. She introduced herself as Janet Morse and said she lived on Cottonwood Lane, which is the far end of the development. She said she had not known about any of this until she saw my post in the neighborhood Facebook group and that she wanted to share something relevant. She held up her phone and showed a video she'd recorded from her kitchen window. The video showed Debra's drone, clearly identifiable by its color and the light pattern, flying along the rear fence line of several properties on Cottonwood Lane and hovering over a backyard that had a swimming pool covered for winter. Nobody had a pool violation. Nobody on Cottonwood Lane had received any violations recently. The drone had just been flying back there, patrolling, for no documented enforcement reason. The room started buzzing. Debra stood up and said something about the footage being taken out of context and that the board had the right to inspect community property. Someone in the back called out that the backyards on Cottonwood Lane were not community property. Someone else said that Debra was mixing up common areas and private residences. It got a little loud for a minute. The other board member who had voted with Debra on the drone purchase, a quiet guy named Dennis Farley, suddenly looked like he wanted to be anywhere else on earth. He had barely said a word all evening. I let things settle down and then I made my formal motion, which Lisa had helped me draft. I moved that the board immediately suspend all drone operations, pending a legal review of the program's compliance with state law and the HOA's own governing documents, that the board retain outside legal counsel for that review at the HOA's expense, and that the $1,100 drone purchase be reviewed for compliance with the operating fund expenditure notice requirements. I had the motion written out on paper, and I handed a copy to the board secretary, a nice older gentleman named Harold who looked faintly relieved that someone was bringing this to an official head. Terry seconded the motion. Carol seconded it as well, which technically meant it had 2 seconds, which Harold noted might not be procedurally necessary but also wasn't a problem. Debra said the motion was out of order because it hadn't been on the agenda. Lisa, who I had asked to attend and was sitting in the second row, stood up and cited the specific bylaw that allows residents to bring motions during the public comment period of any regular meeting. Debra sat back down. The vote was 3-2 in favor of the motion. Terry, Carol, and Dennis all voted yes. Dennis, I think, had been calculating his own personal liability exposure during Frank's speech and had concluded that throwing his weight behind a legal review was the safer choice for himself. Debra voted no. The other dissenting vote was technically Debra voting twice in her own head, but the count was what it was. The drone program was suspended pending legal review, effective immediately. Debra did not look happy when she left that meeting. She walked out before everyone else and I saw her through the window getting into her car, sitting in the parking lot for a minute. I don't know what she was thinking, but I knew we weren't done, and I was right about that. The following week, I got another violation notice. This one was about my garbage bins, claiming they were visible from the street beyond the permitted hours. I had brought them back in on schedule. I had the timestamp on my phone's photo library to prove it, because at this point I was documenting everything as a matter of habit. I filed a formal dispute with the board through the process outlined in the governing documents, attached my photographic evidence, and requested a hearing. The hearing request sat without a response for 10 days. which under our state's HOA law meant the fine was automatically dismissed since the board failed to respond within the required window. I flagged that to Lisa, who noted it for the file she was building. Lisa had also, in the meantime, submitted a formal complaint to the state's HOA Oversight and Dispute Resolution Office on my behalf. The complaint outlined the drone surveillance, the governing document violations, the improper expenditure, and the pattern of targeted enforcement. The Oversight Office sent an acknowledgement letter within a week saying the complaint had been received and assigned to a case officer. While all this was developing, winter kept doing its thing. We had another big snow event about 3 weeks after the meeting, and this one was even more brutal than the first. 2 feet fell in 36 hours, which broke a local record. Temperatures were brutal, and the wind was brutal on top of that. My propane levels dipped low enough that I had to call for a refill during the storm, which was an adventure because the delivery truck got stuck on the main road into the neighborhood, the same icy road that had been poorly maintained all winter, and had to be pulled out by a neighbor with a 4-wheel drive truck. That icy road situation had been a topic at the meeting too. The HOA's contract with the snow removal company required the company to salt and plow the main road within a certain number of hours after snowfall, and that hadn't been happening consistently. When Frank looked at the contract and compared it to the service logs, which the HOA was required to maintain and make available under the transparency law, he found that the company had billed for services that the logs didn't reflect. Someone had either not done the work or not logged it accurately. That was a separate problem from the drone situation, but it was all part of the same larger picture of the HOA being badly managed. Debra had been so focused on policing individual homeowners' driveways from the sky that the actual contracted services the HOA was responsible for had been slipping. The roads were a hazard, and the HOA had spent $1,100 on a drone instead. I brought all of this to the Oversight Office complaint as additional context. About 5 weeks after the HOA meeting, I got a call from the case officer at the Oversight Office, a woman named Sandra Pollard. She was thorough and methodical and had clearly reviewed everything carefully. She said the drone surveillance issue was being escalated because their review suggested it potentially implicated the state surveillance statute, which meant they needed to involve the state attorney general's Consumer Protection Division. She said that office sometimes collaborated with local law enforcement on HOA cases that crossed into criminal territory, and that she wanted to make sure I was aware the situation might go that direction. I told her I was aware that I had an attorney and that I'd be happy to provide any additional documentation they needed. She also said, off the record, that my case wasn't the only one. Apparently 2 other HOA developments in the state had received similar complaints about board members using drones to surveil homeowners, and the Attorney General's office was building a broader picture. My case was one of the cleaner examples because of the video documentation and the written trail. I texted Frank after that call, and he replied with a single thumbs-up emoji, which from Frank was practically a standing ovation. Meanwhile, the neighborhood Facebook group had become a whole thing. People who had never spoken at an HOA meeting in their lives were now paying attention to everything the board did. Glenn Hardwick had apparently started attending every board meeting for the past 3 years and had a remarkably complete personal archive of minutes and meeting recordings that he now shared in the group. People were cross-referencing Debra's enforcement history and finding patterns, properties she'd targeted repeatedly versus properties she'd never cited despite having similar or worse situations. There were some uncomfortable patterns there that suggested enforcement hadn't been applied evenly across the neighborhood. One thing that came up in the group, which surprised me a little, was that several neighbors had received drone-related violation notices and had simply paid the fines without questioning them. When they saw what Frank and I were doing, they started asking whether they could recover those fines. Lisa said that was a separate matter and they'd need their own legal advice. But she also noted that if the board's drone program was found to be unlawful, fines issued on the basis of drone observations could potentially be voided. About 2 months after the first drone incident, just as the worst of the winter weather was finally starting to ease and people were starting to see mud under the snow for the first time, the state attorney general's office contacted Debra Whitmore directly. I know this because Terry called me that evening and told me, his voice carrying a quiet mix of relief and something that sounded like vindication. The AG's office sent a formal inquiry letter to Debra as the HOA's named enforcement coordinator, and as the individual identified as operating the drone based on evidence including the registration of the drone, which was registered to the HOA, but had been listed under Debra's name as operator in the FAA's online system, the video footage documenting overflights, and testimony from multiple residents. The letter asked Debra to respond to specific questions about the drone program and her role in it. Debra apparently got that letter and immediately went to consult a private attorney, because 3 days later the HOA received a letter from Debra's personal lawyer saying Debra was not going to respond to questions in her capacity as HOA enforcement coordinator, because that title had not been properly established by a valid board vote, which was a fascinating thing to claim suddenly given that she had been operating under that title for months. Her own attorney was essentially arguing on her behalf that her authority to operate the drone had no legitimate basis, which undercut her ability to claim she'd acted on behalf of the HOA. It was a legal maneuver, obviously. She was trying to create distance between herself and the HOA so she couldn't be held personally liable, but she was also inadvertently creating distance between herself and any claim that the HOA had authorized her actions, which left her personally exposed. The outside legal counsel the board had retained, following the motion passed at the meeting, filed a report within 6 weeks of being engaged. The report was a thorough read, and Harold, the board secretary, distributed it to all homeowners as required under the transparency law. The report concluded 3 things. First, the drone program as operated was not authorized by the HOA's governing documents. Second, the operating fund expenditure for the drone purchase had not been properly noticed to homeowners as required by state law. Third, the drone overflights of private residential property without homeowner consent likely violated the state surveillance statute, and the HOA should not have been involved in that program. The report recommended that the board formally terminate the drone program, seek to recover the $1,100 expenditure from the individuals who approved it improperly, and provide notice to all homeowners who had received violation notices based on drone observations that those notices were void. At the next board meeting, which was also well attended, the board voted to formally terminate the drone program. Terry and Carol had been working behind the scenes and had also gathered enough homeowner signatures to call for a special election to recall Debra from her position as HOA president. Under the bylaws, a recall required signatures from 25% of homeowners. They had signatures from 41%. Debra did not wait for the recall vote. 2 days before the special election was scheduled, she submitted a resignation letter to the board. No explanation, no farewell message. Just a letter saying she was resigning effective immediately from her positions as HOA president, and she noted pointedly, as if still insisting it was real, enforcement coordinator. Terry Bloom was elected HOA president at the special election by a wide margin. Carol Shin was voted in as vice president. They immediately moved to establish a proper set of board procedures, including a rule that any expenditure from the general fund over $500 required advance notice to homeowners, and that no enforcement methods involving recording equipment could be used without prior legal review and board vote. On the legal front, Debra's situation did not simply go away when she resigned. The Attorney General's Consumer Protection Division, after reviewing everything, referred the matter to local law enforcement for investigation of the state surveillance statute violation. 2 detectives from the county sheriff's office contacted me about 6 weeks after the referral to take my statement and collect the video evidence I had. They were professional and thorough. I gave them everything I had, including the drone footage, the doorbell footage of Debra photographing my property, the cease and desist documentation, and my attorney's contact information. The investigation took a couple of months, as these things do. During that time, life in Pinecrest Meadows got noticeably better. Terry and Carol were running the board in a way that felt like they were actually serving the community rather than policing it. The snow removal contractor was put on notice that the service logs needed to reflect actual work done, or the contract would be terminated. The main road was properly maintained through the last 2 snowstorms of the season, and nobody's delivery truck got stuck on the way in. I shoveled my driveway as needed, because I always had. No violation notices arrived. No drone hovered overhead. It was remarkable how much more pleasant the experience of owning a home in Pinecrest Meadows became when the HOA was focused on the things it was actually supposed to be doing. The outcome of the law enforcement investigation came in the early spring, just as the last snow was melting off the yards, and people were starting to think about getting their gardens ready. Debra Whitmore was charged with 1 count of violating the state's aerial surveillance statute, a misdemeanor under our state's classification, for using a drone to conduct surveillance of private residential property without the resident's consent. The charge specifically cited 3 incidents: my property, Patty Osai's property, and the Cottonwood Lane backyards filmed by Janet Morse. Debra's attorney negotiated a resolution that did not involve jail time, which is standard for first offense misdemeanors under that statute. She was ordered to pay a fine of $3,000, complete a community service requirement, and the conviction would appear on her record. The HOA's outside legal counsel also filed a civil action on behalf of the HOA to recover the $1,100 drone purchase from Debra personally, on the grounds that she had operated the program without proper authorization and had exposed the HOA to legal liability. That action settled out of court with Debra reimbursing the HOA's general fund. On the day the settlement was finalized, Terry sent a message to the neighborhood Facebook group letting everyone know. The response was one of the most active threads the group had ever seen. Glenn Hardwick posted a photo of his spotless driveway with the caption, "No citation in sight." Patty Osai posted a photo of her recycling bins, sitting out on collection day, with a thumbs up. Frank sent me a private message that just said, "Good work, Joe." I was sitting at my kitchen table when I read that. The same table where Frank and I had sat in January with his thermos of chili and my video of the drone, figuring out what we were dealing with. Outside the window, the snow was completely gone, and the yard was starting to show the first green hints of spring pushing up through the mud. My driveway was dry and clean without any particular effort beyond being a normal person who maintains his property. I thought about the whole thing for a while. How it started with a violation notice during an active snowstorm. How it escalated because one person decided that flying a drone over her neighbors' homes was an acceptable way to run a neighborhood organization. How it might have stayed small, just another HOA irritant, if I hadn't happened to be standing at my kitchen window at the right moment with my phone handy and my tolerance for nonsense fully exhausted. There's a version of this where I pay the fine, grumble about it to Frank over the fence, and go back inside. Plenty of people do exactly that, which is why HOAs with a Debra Whitmore problem often keep having a Debra Whitmore problem for years. The math works for someone like Debra, as long as people keep paying the fines and not pushing back. The moment people start comparing notes, pulling out their CC and RS, calling attorneys and showing up at meetings, the whole apparatus collapses pretty quickly because it turns out that the authority Debra had wasn't nearly as solid as she made it sound. The drone was the mistake that made everything visible. If she'd stuck to strongly worded letters and fine notices, she probably could have kept grinding people down for years. But flying a surveillance drone over people's private property in the winter, filming their driveways and backyards from 50 feet up, that's the kind of thing that unites a neighborhood fast. It's visible. It's documentable. It feels personal in a way that a form letter doesn't. And she registered the thing in her own name with the FAA. I mean, honestly, the spring came on warm and welcome that year. The neighborhood ice melted, the roads cleared up for real, the tree on the corner of Birchwood Circle that had dropped a big snow-loaded branch across the sidewalk in January finally got properly trimmed by the landscaping crew the new board had re-engaged. People were out walking dogs and kids were out on bikes for the first time since fall. It had the feeling of a neighborhood that had gotten through something together. A few weeks after the legal resolution, Terry organized a neighborhood cookout in the common area green space, partly as a standard spring kickoff, partly as an unofficial celebration of the new board's first few months. I went. Frank was there with his wife. Patty came. Glenn brought some kind of elaborate potato salad. Marcus Webb was there. Janet Morse drove over from Cottonwood Lane. We talked about the winter, about the snow, about the drone, the way you talk about a shared experience that's far enough in the past to be funny now. Glenn did an impression of Debra standing at a board table saying, "Community resource for maintaining neighborhood standards." That was so accurate that half the crowd had been there for the original delivery, and still laughed loud enough that a dog 2 houses over started barking. I talked to Terry for a while near the grill. He said the board was working on revising the CC and RS to include clearer language about what monitoring methods the HOA could and could not use. He also said they were looking at a community committee approach to enforcement, where violations were reviewed by a rotating panel of residents rather than decided unilaterally by a single board member, which would prevent the kind of targeted enforcement pattern that Debra had developed over the years. It sounded like a good plan. It sounded like people who actually wanted to live in a functional community making the thing work. I told Terry I appreciated what he and Carol were doing, and that I was happy to serve on a committee if they ever needed people. He said he'd keep that in mind. I walked home after the cookout in the long spring evening light, the air still cool enough that I had a jacket on but warm enough that I didn't need to zip it. My driveway was dry. My front walk was clean. There were no drones in the sky. I went inside and made coffee and stood at the kitchen window, the same spot where I'd first seen that little blinking red light hovering over my driveway in the gray January cold. It looked like an ordinary neighborhood out there now. People pulling into their driveways, kids riding bikes in the last of the evening light, a dog sniffing along the hedgerow at the DeLuca's place. Normal, peaceful. I thought about Debra for a moment. Not with anger, because at that point the anger had been processed and discharged over weeks of meetings and legal back and forth and community organizing. More with something like bemused disbelief, that a person in her position had made so many choices that predictably led to exactly where she ended up. She had authority within a narrow, legitimate scope, and she kept pushing beyond it, kept treating the HOA not as a tool for the community, but as a personal enforcement apparatus. The drone was the clearest expression of that impulse. It wasn't enough to send letters. She needed to watch, to see everything from above, to know. And in the end, that need to watch is what got her watched in return. My doorbell camera, my phone camera, Janet Morse's kitchen window, multiple neighbors' outdoor cameras that they'd set up after seeing the drone and wanting to document it if it came back, the FAA registration database, the HOA's own financial records. Debra had been so focused on monitoring everyone else that she'd completely failed to consider how much monitoring was being turned around on her. The coffee was good that evening. I stood at the window for a while, just watching the neighborhood do its quiet thing. Then I went and sat down on the couch, pulled up something to watch on TV, and thought about nothing more complicated than whether to order pizza or cook something for dinner. I ordered the pizza. The winter had been long and cold and genuinely aggravating in ways that went beyond the drone, beyond the HOA, beyond all of it. Burst pipes in 3 houses on the far side of the development had been a whole thing. The propane shortage during the big storm had been stressful. The icy roads had been dangerous. People had dealt with furnace issues and car battery deaths, and all the thousand small miseries that a serious winter brings. But the neighborhood had come through it together. That counted for something. People who'd never really spoken to each other before the drone incident had exchanged phone numbers, compared notes, and shown up at the same meetings. Frank and I had always been friendly across the fence, but we'd become genuinely close over those few months of working through the legal situation together. Patty and I waved to each other every morning now. I'd had dinner at Glenn and his wife's place once. Marcus Webb had helped me dig my truck out after the second big storm, and I'd helped him deal with a frozen section of his gutters the following week. Good neighbors, it turns out, are what happen when you have a common problem and a community that decides to face it together rather than just keeping quiet and paying fines. The HOA, as it was being run under Debra's watch, had actually been working against that, turning neighbors into isolated subjects of enforcement rather than members of a community. The drone was just the most literal expression of that dynamic. Surveillance from above, disconnected, impersonal, watchful in the worst possible way. The new board was doing something different. More meetings where residents could actually weigh in before decisions were made. A newsletter that reported what the HOA's budget was actually being spent on. An open process for challenging violations instead of a take-it-or-pay-it structure. Small things, but they added up to a community that felt like it belonged to the people who lived in it. By the time the following summer rolled around, and people were thinking about mowing their lawns instead of shoveling their driveways, Pinecrest Meadows felt like a genuinely different place. Not dramatically different. Still a normal neighborhood with normal small tensions and occasional issues that needed to be worked out. But different in the baseline way that a community feels when it's running on trust instead of fear. I still have the video of the drone saved on my phone. I've backed it up to the cloud twice, not because I'm planning to use it again, just because it's a record of what happened, of a very cold Tuesday morning in January when I stood in my slippers on my porch filming a drone that someone thought she had the right to fly over my home, and decided that actually no, she didn't. There are things worth fighting for in this life. Your home is one of them. Not because of the property value or the curb appeal or any of that, but because of what it means for your home to be yours, genuinely yours, not subject to someone else's unchecked surveillance and control. That's a simple idea. It's the kind of idea that people can usually agree on pretty quickly once you put it in plain terms and show them the video. 14 inches of snow, a hovering drone, a cease and desist letter, a neighborhood Facebook post, and a very good attorney. That's what it took. It was worth every minute of it. The driveway looked great all winter, by the way, always shoveled on time. Sometimes I'd go out there and shovel even when I didn't have to, just because I like the feeling of getting it done and I enjoy being outside in the cold when it's quiet and the snow is still fresh. Nobody filed a citation. Nobody sent a drone. Just me, my shovel, my boots on the snow, and the peaceful gray winter sky. Exactly as it should be.